You're listening to a special edition of We Get Work, recorded live from Workplace Horizons 2025 in New York City, Jackson Lewis's annual labor and employment law conference. Over 500 representatives from 260 companies gathered together to share valuable insights and best practices on workplace law issues impacting their business today. Here's your personal invitation to get the insights from the conference delivered directly to you. We'll see you in 2026. Ladies, welcome to Workplace Horizons 2025 and our Live from Workplace Horizons podcast studio. Thank you for joining us. In the studio with us this afternoon, Marla Presley, principal in the Pittsburgh office of Jackson Lewis, Lindsay White, principal in the Baltimore office of Jackson Lewis, and from Salt Lake City, Sierra Vieira. Welcome, ladies, today to the show.
Thank you for having us.
Marla, why don't you start by telling us a little bit about yourself and your practice? And this session is unique because you all actually do a little bit of a different thing for our clients. So Marla, over to you first.
Thank you. So I am a litigator in the Pittsburgh office, and I handle every type of litigation with a focus on wage and hour litigation against private companies brought by employees and the Department of Labor.
Lindsay, how about you?
I also am a litigator. I have a robust advice and counsel practice, but I would say I primarily litigate, and my background is as an EEOC trial attorney. So I get looped into a lot of EEOC specific actions.
And Sierra, how about you?
No, I'm also a litigator. Seeing a trend here. I do workplace health and safety law, primarily practice in California, but I also represent employers across the country.
So the title of your presentation was, not surprisingly, litigating employment cases. How about that? But really, more importantly, effective strategies for agency actions. And we know there's an awful lot happening at the agency level these days. So Lindsay, why don't you tell us a little bit about your presentation, what you covered, and what you wanted to share with our attendees?
Sure. We focused on OSHA, EEOC, and Department of Labor litigation and actions. So each of us shared what are some developments at the agency level with the new administration, and there have been many developments for each of the individual agencies, and my colleagues can speak more in detail on their specific agencies. But we also talked about strategies for both preventing and defending against agency litigations and investigations.
So Sierra, let's talk about OSHA litigation first. What are some of the major issues and trends that are facing employers right now?
So one of the big things we talked about was just making sure employers know their rights and the rights of their employees during an OSHA inspection. That tends to be one of the biggest issues that we have to handle when a client or a case comes our way, is making sure the agency isn't overstepping. Right now, we also have a lot of uncertainty as far as what this new administration is going to do with its enforcement practices and how states with state plans are going to respond.
And the EEOC?
There have been many changes at the EEOC. Number one, with many of the agencies, there was the voluntary retirement offers. And so we're seeing a lot of investigators and other staff opted for that. So lower numbers of investigators mean less attention to any one action. We're also seeing at the EEOC, we have a new chair, an acting chair, who was appointed by President Trump and has announced a pretty radical shift in priorities. We're seeing a lot of enforcement of DEI plans and people who complain about DEI programs as sort of whistleblowers, retaliation actions. So we're seeing a lot of those types of cases. We're also seeing the EEOC voluntarily dismissed all of its gender identity litigation. And it's our understanding that the commission is accepting charges on that basis, but not really enforcing or pursuing any kind of litigation. We've also seen a proclamation to eradicate anti-American bias. So that's going to be an increased focus for the EEOC in the years to come.
And the DOL, Marla?
We see some overlap between the DOL and OSHA. There's been big changes. There's a new Secretary of Labor. you would expect with a new administration changes, but we're seeing a very big pendulum swing here. And I would echo Sierra's characterization of things as very uncertain. One of the focuses of our presentation today from the DOL perspective is as it pertains to some of these agency investigations and audits, that employers really need to arm themselves with the knowledge and the resources to the extent that these audits and investigations continue or even go on an uptick, to be prepared if the DOL comes knocking.
So, given the breadth of your presentation and all the things that you covered, what issues were really resonating with employers? What did they want to know about? What did they ask you? Lindsay?
I think we got a lot of questions on EEOC practice and what to do in certain situations. And it seems to us that the different offices are taking different approaches. So, for example, historically, the agency has not offered mediation ever. If a position statement had been filed. It's only pre-position statement. So now we're hearing an uptick in mediation being offered after the position statement is submitted, which we suspect is a result of fewer personnel to help, actually investigate cases. But I think people were really interested in sharing their experiences with the different agencies and hearing from other participants.
So the decrease in the number of attorneys at the EEOC and other agencies, do employers view that as good news, or are they just really uncertain as to what's going to happen?
Just speaking, from the EEOC perspective, I think that there is a decrease of sort of concentrated investigations. It's always been the case that the EEOC cannot truly investigate the number of charges it receives. So it will receive a charge, it'll get a position statement, there will be some sort of determination. But in recent years, it's been a form letter that says, basically, we're closing the investigation, we make no finding, here's the notice of right to sue. So I think we're seeing more of that kind of action where the EEOC is meeting its statutory mandate to sort of receive the information, but cannot really analyze it, conduct investigations, conduct interviews, get additional information, and make an actual finding.
So a lot of folks have sat in those chairs at this table over the past couple of days, and we're hearing things like patience, proactivity. What would you say to the clients could be some key takeaways at the OSHA level, at the EEOC level, and with the DOL? What's the most important thing for clients to know right now? Marla?
At the risk of sounding sales callish right now, I would say that even though on the DOL side, a lot of investigators similarly took the buyout, but what we're hearing from our insiders at the DOL is that overtime, for example, is an apolitical issue. It's not an area of enforcement where we would expect with this administration to see a decline in investigations or lawsuits. So I think employers need to be prepared at all times to take appropriate action if there is a complaint or an unannounced or random audit. And one of the things that we shared as a group and some of the attendees shared with us is that the DOL enforces not just wage and hour laws, but the FMLA, for instance. And we're seeing investigators go in to investigate an FMLA complaint. And when an employer turns over records, they use that as the back door to get the records that they need to say, oh, you also have systemic wage and hour violations. So we cautioned the group before you turn over anything, even if the issue seems simplistic at first. You really need to involve your in-house team, your external counsel, because you don't know. I would say almost never is an investigator looking at a document with blinders on and said, okay, this just pertains to the FMLA, so I'm going to ignore those wage and hour violations.
Sierra, what about you?
Yeah, on the OSHA front, I think employers need to continue to be proactive, promoting a good safety culture at their work site, making sure that you have a comprehensive safety program, you're doing regular trainings, and also that you're keeping good records of those trainings. Another thing, again, at the risk of sounding sales pitchy, call your counsel if you do have OSHA show up. Oftentimes OSHA will show up for a very limited inspection, but depending on what they learn during their inspection, they may expand the scope. So you need to work with your in-house and external counsel to ensure that a fair inspection is conducted.
Okay. And Lindsay, on the EEOC front, key takeaways.
There's so many key takeaways, but I think number one, if you have either an internal complaint or a charge of discrimination that dovetails with one of the priorities that the EEOC is currently focused on, you need to be really proactive about that and make sure that you're handling it, appropriately. Even if it's something that hasn't, yet turned into, for example, a termination, if it might raise one of these issues. In addition, we have a lot of clients who have, are in conciliation, which is the EEOC's version of sort of settlement, pre-suit settlement. And these cases are just sitting because there's no quorum. So the EEOC can't authorize systemic or large-scale litigation. They can still authorize sort of individual suits or smaller suits. So I think the long game is patience. It's so easy to say, well, we know that they can't authorize this, so we just want to, take action and get it off the plate. But, I think for right now, let's not be the test case. Let's see how this all plays out. And hopefully in a couple months, we have a little more clarity.
Let the dust settle, as it were. Sierra, Lindsay, Marla, thank you so much for joining us today at We Get Work, live from Workplace Horizons 2025, and enjoy the rest of the conference.
Thank you.
Thank you.
Thank you for listening to Jackson Lewis's podcast, We Get Work. Focused solely on workplace issues, it is our job to help employers develop proactive strategies, strong policies, and business-oriented solutions to cultivate a workforce that is engaged and stable. Please tune into our next program, where we will continue to tell you not only what's legal, but what is effective. We Get Work is available to stream and subscribe on your streaming platform of choice, including Apple Podcasts, Spotify, and YouTube. For more information on today's topic, our presenters, and other Jackson Lewis resources, visit jacksonlewis.com. As a reminder, this material is provided for informational purposes only. It is not intended to constitute legal advice, nor does it create a client-lawyer relationship between Jackson Lewis and any recipient.